Welcome to the PSRB Lawcast. I'm your host, Adam Wright. Each episode features dynamic conversations with attorneys from the law firm of Pellegrini, Seeley, Ryan, and Blakesley in Massachusetts. And we try to bring you information about the various aspects of personal injury law and the legal process because we understand approaching a law firm to help you can often be intimidating. And that's why this podcast is designed to make personal injury law easier to understand and to help you navigate the processes with greater comfort. Now, you have to remember every case is different, and in order for us to provide you with accurate information and advice relevant to your specific circumstance, it's really important to set up an appointment with one of our attorneys to meet in person. Today, we're discussing slip and falls, and to do that, we want to welcome PSRB attorney Enrico Maio to break it all down for us. Prior to joining the firm, Attorney Maio worked in New York City, representing individuals and corporations in commercial disputes, securities, arbitrations, and personal injury actions, of course, giving him valuable knowledge and insight into successfully negotiating and litigating civil cases on behalf of his clients. Enrico is licensed in Massachusetts, Connecticut, and New York, and is a graduate of Boston College and St. John's University School of Law. Enrico's practice is concentrated mostly in the area of personal injury litigation, including representing those individuals injured as a result of slip and falls and motor vehicle accidents, medical malpractice, defective products, construction site accidents, and dangerous property conditions, which is what we're going to talk about today. Enrico, nice to have you here.
Hi, Adam. How are you doing today?
I'm doing great. You know, it's an important area of personal injury law because I think we've all taken a tumble at some point in our lives, right? And I'm sure for most of us, once we realize we didn't break anything, we breathe a sigh of relief knowing it could have been much worse. But for many folks, their falls result in serious injury, and oftentimes it's because of somebody else's negligence. So I think what I'd like to do is just maybe we could outline what are the most common situations under which slip and fall accidents happen.
Yeah, Adam. So there's two main ways people typically find themselves in a slip and fall situation. The first we see is mostly at indoor commercial businesses. And the second, as you mentioned earlier, would be outside on snow and ice. So, why don't we talk a little about falling indoors at a commercial business, since it's something that happens quite frequently, more often than even slipping outside. The most common scenarios, and there are usually three, where we see people falling at a business, is one where we have a staff member of the store that might have mopped up a recent spill. And under this circumstance, the business would be found at fault if they fail to warn the customer that the floor has been mopped and is moist or wet. And this is frequently seen where they fail to put down any cones or wet floor signs or cordon off the area, or otherwise make it known to their patrons that they need to be careful when they're traversing that area.
Yeah, this could be a dangerous area. Stay away.
Yeah. And so that's the first most common scenario we see at businesses where our clients are slipping and falling. The second is where another patron or customer of the store comes along and perhaps drops a product they're looking at, or spills something they may have had on their person or in their purse. And under this circumstance, the business would be found at fault if they had actual notice and they didn't do anything in a timely fashion. So meaning it was reported to them by the person who dropped it or another customer, and they just sort of twiddled their thumbs and maybe let 10, 15, 20 minutes go by. Somebody else comes along and they fall. They can be found responsible for that. Do
they have a responsibility to patrol the area to make sure nothing has fallen? I mean, I've seen many times, in the grocery store, for example, someone has dropped a grape or a cucumber or a tomato or something on the floor, and I'll try to kick it out of the way, but oftentimes I'm sure it goes unnoticed. Does the store have an obligation to patrol areas that would most likely become hazardous?
Yes, and so things have changed and thankfully become more favorable to those that have fallen and been injured in businesses. In the past, you would find that you would actually have to have actual notice. The store would have to know about the condition in order to be found responsible. But over the course of time, the laws have changed, making it easier to bring cases where the stores don't, in fact, have actual notice. So, for example, if there was sort of a constructive notice where the business did not in a reasonable period of time make any attempt to learn of any slip or trip hazards on its property, they could be found at fault. For example, if somebody dropped something and it was there for under 10 minutes, and the store didn't figure that out, that might be reasonable. They might not be found at fault for that. However, the longer it's there, 15, 20 minutes, 30 minutes, the more probable it becomes that it should have been found by the store, and that they are going to be responsible for that. And the change in the law occurred sometime in 2007, where the court adopted an approach that they call the mode of operation approach. Under this approach, businesses can be found responsible for spills that are foreseeable. And I think you mentioned one that's one of the most common. So for example, the grape that you mentioned. In a fruit and vegetable section in a grocery store, it's quite common to see people handling the produce. And
eating it.
Yeah, fair enough. And what happens a lot of times is it ends up on the ground. And so that's foreseeable because that's the mode of how they operate. They have these out in bins for customers to peruse and touch and pick up. And it's foreseeable that they're going to be dropped. So there's some type of constructive notice there that under this mode of the way they operate their business, that, they're going to drop grapes or other produce on the floor. So the law requires them to undertake a method in which they're going to more frequently monitor those areas. So what that period of time is, again, comes down to a reasonable standard. But, if they're not monitoring those areas where something like this can occur, within a reasonable period of time, and again, that is sort of a common sense standard. There's no hard and fast rule that it's 5 minutes or 10 minutes or 20 minutes. But I would say that, when you're starting to get over 15 minutes, when staff members not coming through that area, that becomes more probable and likely that if somebody comes along and falls, that the store would be responsible.
How do the stores monitor the amount of time? Do they have like a reporting structure? Like, when you go into the bathroom sometimes, it'll say, when was the last time this was cleaned? Do they actually have a check-in process where they say that they had been there within the last 10 minutes?
Well, some stores do and some stores don't. There's no hard and fast rule that requires that they have them in place. I think you'll find that some of the bigger, more well-known stores or entities or chain stores in fact do have these logs or sweep logs, with how often somebody's come through an area. And you might find it less frequent in more mom and pop stores. So, that does sometimes help or hurt cases depending on what is in those records and or whether those records even exist. But there's no hard and fast rule that requires them. But it could be a detriment to the store if they don't have any logs showing that they made these attempts.
What about other kinds of hazards, like, for example, people tracking water in from outside or snow or that kind of thing? I mean, we've had some really rainy days the last couple of days, and let's say somebody tracks water in and the floor is slippery. Is it the same standard of care and operational awareness that the stores have to be cognizant of?
Yeah, so we did talk about the first most common scenario, which was the staff, leaving a wet floor after mopping it. And you find the second most common scenario, where a customer might spill something. And, the last and third most common scenario would be where, and it's somewhat of a hybrid situation where people track in from outside indoors, rain or snow, water, on their feet as they go in. And it's only been recently where this type of case is even something we can really bring successfully. Prior to 2019, this situation they called the transient water situation was not something for which we could help recover for plaintiff's injuries. In 2019, some of the Massachusetts courts started to change their thinking on that, essentially saying, that businesses must be reasonable in removing water that's tracked in by customers. And if they don't, they could be found at fault for it. So for example, they should be putting mats out during inclement weather. The argument could be made that just like in the produce section, on a rainy day or snowy day, they should probably have somebody more frequently monitoring the means of, entering and exiting the store. So again, as things change, the cases have become more favorable for our clients over the years, but we'd like to see that even more strongly picked up by other courts or higher courts in the state. But some of the lower courts have now started to say that, yes, in fact, transient water conditions are something stores can be found responsible if they just essentially do nothing about it and twiddle their thumbs.
Yeah. Well, I mean, you would think it would be a pretty obvious place for things to occur, and they would have some kind of reasonable responsibility. When somebody gets hurt in a store, I'm sure it's probably a little bit different outside in some other situations, but in a store with a slip and fall, what typical injuries do we see?
It runs the gamut. I mean, it depends on the person. It depends on how violent the fall is. And it, depends on the hardiness of the person as well. But you can see anything from a strain, of your neck or your back to contusions of, your knees, your hands, your wrists, your elbows, mostly on depending whether you slip forward or slip back. On occasion, we'll see people that will break a limb. And sometimes that neck strain or back strain is more than a neck strain or back strain. You potentially may have herniated a disc and you may need surgery and you may miss significant time from work. So it runs the gamut.
Let's talk a little bit about outside. We know in a typical winter, there's a lot of snow and ice. Is there a responsibility of a property owner to keep the snow and ice from well-traveled walkways, for example?
Well, snow and ice outside is the second most common way we see people slip and fall. And it depends, the level of scrutiny to the landowner depends on whether they're private or whether they're, public, meaning a government entity. So if we're talking about somebody's private property, a parking lot, a driveway, a sidewalk, a walkway, they've got an obligation to remove snow and ice in a timely fashion. Again, it is a reasonable standard, and it comes down to what common sense.
And when you say reasonable standard, it's what would a reasonable person expect?
Absolutely. And again, it's not defined by any specific measure of time, but it's just if you got a group of people together like a jury, what would the average jury person or the average person out in the population think is reasonable, and what they wouldn't in a lot of cases are hashed out over that issue.
Yeah.
For example, if a snowstorm ended and, somebody came along and slipped and fell and it had been, under an hour after the storm had completed, would it be reasonable to expect the landlord to have cleaned it by then? I don't know. Once you start getting over an hour, now it starts to, the scales start to tip in the other direction, and it becomes more and more unreasonable that they didn't get out there and remove snow and ice. And if somebody then comes along, the case, increases in strength as to they should have been out there. They should have done something. They didn't do something. Somebody was injured. It starts to become 1 + 1 = 2 as far as who's responsible for the accident.
Yeah. You'd mentioned also if it was a government or a public entity, how is that different than if someone has a private property?
Yeah, I mean, before we get onto that, there's one other thing I wanted to mention because it comes up a lot with respect to homeowners. And again, this is along the lines of private, property. But you might have a public walkway, a sidewalk that runs adjacent to your house. And the cases with respect to that are difficult. The law requires you, in order to be responsible as a homeowner or a business owner adjacent to a sidewalk, a public sidewalk, requires that the snow or the ice that the person slipped on was unnatural. What we mean by that is it was caused to accumulate or collect because of something the homeowner, the business owner, the landowner did. For example, if they had a gutter that overhung the sidewalk and it was faulty and it was pooling water in one area, or they did something, that caused, the sidewalk to be unlevel, and it caused water to pool excessively in one area. That's unnatural. It didn't just fall from the sky that way. It's been pooling that way or collecting that way because of something the homeowner did. Then they could potentially be responsible for somebody falling on their sidewalk. But if they don't remove snow and ice from the sidewalk and they didn't cause it to be there unnaturally, as we just described, and somebody comes and slips and falls, they can't bring that case against the homeowner successfully. The town, if they have an ordinance, could fine the homeowner, but they wouldn't be responsible necessarily for the injury to the person.
Interesting. I know that the last house I had a huge, it was on a corner. And so the amount of walkway that, the sidewalks surrounding the house, it would take me longer to do that than it would my driveway.
Now, I'm not saying don't go and do it.
Right. So that was my question is if, and there was an ordinance in Westfield, Massachusetts, where you had to, that was your responsibility to clear. Now, if again, I didn't do it and somebody fell walking their dog, they couldn't sue me necessarily, but the town could fine me for not having it done.
The homeowner, again, wouldn't be responsible beyond potentially being fined by the town. However, the reason to do it is one, this is the right thing to do, but right. Two, it's not going to prevent somebody from necessarily bringing that lawsuit against you, even if it might not ultimately be successful. Do you want that headache? Probably not.
Right. Yeah. But what about if just on a homeowner's level, let's say somebody came up to your property and you hadn't had a chance to get out and clean the ice off. It's a big snow day. You're stuck inside. You haven't done it yet. The UPS guy comes to your house, wipes out on your driveway, or a friend comes to check on you, wipes out, has a serious injury. Are you liable for that?
So again, now we're actually talking about walkways or your driveway on your property, not the public sidewalk Correct. That runs adjacent. So I think the standard for that, again, is the reasonableness standard. Okay. So if it's been, an hour plus after the storm, yeah, you should get out there and clean it, because if somebody comes along and falls, you could be found responsible for that, especially if they're expected. So you expect the mailman to come on a regular basis. If you're expecting company, even if you weren't expecting it, you still got an obligation to get out there as long as somebody came onto your property lawfully. Maybe you had a friend that was going to visit unexpectedly. But again, they were there lawfully. And so if you're going to be out of town or something, you probably should hire somebody to take care of it while you're away. So you can't just, hide behind an excuse, like I was away or was out of town. You've got an obligation to clean your property within a reasonable period of time and to do it in a reasonably safe fashion.
Do we see people who are delivering products to your house fall and slip and injure themselves? Is that the type of thing we see most with homeowners? Where you would then have
I don't know about that because I believe some of these, professionals who deliver, UPS or FedEx,
right.
They're trained on what to do and not do. They may be wearing specialty shoes. Sometimes they may forego even walking on the harder surfaces and walk on the snow because across the grass, which may provide more traction for them than
Sure.
walking across potentially a slick driveway or walkway. So, I wouldn't say necessarily that we see professionals suffering more slip and falls, maybe because they receive that training, but it does happen. Usually it's kind of the unsuspecting, lay person that comes along that might fall. And that's really who you're removing that snow and ice for.
Right. And also a great way to ensure you're having homeowners insurance.
Yeah, that's always a good thing.
Right. When somebody is injured, how do they go about reporting that injury? Is it something they would contact, the store about first? Do they contact a lawyer first? They go, they're obviously they're going to get medical treatment if they're seriously injured. What's that process like?
Sure. And I think it depends on.
Let's go back to the store analogy.
Yeah, it depends on where you fall. So, the key to any case, whether it's a slip and fall or not, is documentation to corroborate what happened to you. Because at the end of the day, you've got to be able to prove it. Particularly when it comes to slip and fall cases, that is a a really big issue because the situations that cause you to slip and fall are often transient in nature. They're here 1 second, they're gone the next. For example, we've been talking about snow and ice. Well, snow and ice melts, and spills in stores, for example, are cleaned up, or they may evaporate if it's just a recently mopped floor. So first thing you should do before even reporting it is, if you've got a phone, and most people have phones in their pockets nowadays with cameras, is take a picture of what caused you to fall. Take a video of what caused you to fall. Even better, make sure the date and timestamp are on so you can confirm that, hey, that's what it looked like at the time I fell. So nobody can say later on, oh, no, it wasn't, or that's not how it was. And then the second thing that's probably important to do is eyewitnesses. Somebody came to help you. Another patron in the store. Get their information. I know you're probably frazzled. I know you just fell. You might be in pain. Even if you can't do these things yourself because of that, ask somebody around you to, hey, could you take a picture of this? Or, can you just write down this person's information? Because you need evidence to corroborate what you said. And lastly, once you've done those two things first, I think in order of importance, you want to report it to the store so they can make a record of it and potentially preserve, any videos that may have captured the fall. And you see a lot of that in, bigger stores, that they have videos everywhere. Maybe, again, not necessarily a mom and pop store, but most of the bigger stores should have videos. And if you don't report it in a timely fashion and the video gets taped over or, is otherwise, disposed of, you may have lost your opportunity to prove you fell the way you said you did.
One of the things I know in personal injury cases of all types that we've talked about a lot over the course of this podcast series is statute of limitations. How long you have to file a claim or to put somebody on notice that you've been injured. Does that exist with slip and falls as well?
Yes, with some, intricacies there. So generally speaking, most personal injury cases in Massachusetts have what we call a 3-year statute of limitation in which to file a lawsuit in court if you can't otherwise resolve it, through settlement or some other means. With slip and fall cases, particularly those that involve snow and ice, there are more immediate and pressing deadlines that need to be satisfied in order to make sure you can then later on bring that case. So the first thing is, if you slip and fall, again, in a business we've been talking about, that generally, again, has a 3-year statute of limitation. Now, when you're talking about slipping and falling on snow and ice, that has that extra little requirement that you give 30 days written notice to the property owner of your fall. And it has to be done with very specific requirements. It has to be sent to a certain person. It has to have certain information on it with specificity, date, time, location. And if you don't do that, you run the risk of them being able to get out from under being sued ultimately within those 3 years. Because if you don't give them that 30-day notice, they could argue that they were prejudiced and didn't have an opportunity to secure information that they could use to defend themselves, in the form of, witness statements or videos that maybe they tape over every so many days. So that you run the risk of that. It's even more concerning when you slip and fall on public property, which I don't think we talked too much about. So public property would be, again, a government-owned city, state, town, government agency. Those are roadways, sidewalks, highways. If you do not give the 30-day notice to a government agency, that is the death knell for a case. Unlike private property, where they would have to prove they were prejudiced by not receiving that 30-day notice, government agencies can hide behind the fact that it was not given within 30 days, regardless of whether they were prejudiced or not. And that will not allow you to then ultimately bring that case forward beyond that. So it's really important that you reach out to an attorney right away in a slip and fall case on snow and ice in particular, because the attorney will know which requirements need to be satisfied and, which ones, if they're not satisfied, eliminate your ability to bring a claim. So that's pretty tricky. But, government agencies are afforded a lot of other protections that private agencies are not.
It's interesting. I was going to say that, this seems to be one of those areas of personal injury law that, we always say contact an attorney as soon as you can, but this one seems to really be important to do quickly.
Yeah. And I'll throw another monkey wrench in there. Even if you fall on a government property, you've got another requirement. A presentment notice must be given within 2 years. So you got that 30-day requirement if you fall on snow and ice on government property.
What's a presentment notice?
It's more or less along the same lines as that 30-day notice requirement for snow and ice. But if you fall, maybe it's not on snow and ice, but you have some other injury, because that snow and ice notice can double as the presentment letter.
You're walking up City Hall steps and there's a crack in the stair and it's crumbling and you fall.
Right. Again, not necessarily what we've been talking about, slip and fall case, but a fall. You had a fall on a government property. Typically, you would have a 3-year statute of limitations if it was a private property. But on a government property, you've got to send a presentment letter, very much like that snow and ice letter, who, what, where, when, with specificity to the right person, to the right address. That has to be given within 2 years, even though the statute of limitations is 3. And if you don't send that special presentment letter with all the things that it requires within those 2 years, that will eliminate your ability to bring a claim against the government, city, state, town, or agency within the 3 years. Doesn't matter.
Yeah.
So that's why it's always important, because the attorneys can figure out who owns the property, whether it's private or public, and what notices need to be given in a timely fashion that will allow you to ultimately bring the claim if all the other elements are there to bring a successful claim.
What about compensation? We talked about, obviously, medical bills and time missed from work. Is there any kind of compensation for pain and suffering in a slip and fall case?
Well, yeah, like other types of cases that we handle, that I handle, whether it's motor vehicle, medical malpractice. Yes, of course, you are entitled to get reimbursed for any and all damages that are causally related to the fall. What I mean by damages, typical things one might consider hard costs. For example, your medical bills, your lost wages. These are things that can be calculated. And then things that are more subjective, pain and suffering. Absolutely. And again, that all depends on the nature and extent of your injuries. And, no two cases are the same. So again, it depends. Was it a strain? Was it a sprain? Did you need surgery? Do you have permanent dysfunction? Did you lose time from work? Were you ever able to go back to work? And all these things factor into the value of the claim. But yes, you can get those hard costs we talked about where you can look those up, the bills, the lost wages. And of course, you can get pain and suffering above and beyond that. And I will mention that some of these places, especially big commercial businesses, will have what's called no fault insurance up to a certain dollar amount. So let's just say you fall, at somebody's, you're grocery shopping, you fall in the grocery store, and maybe they're not even necessarily at fault for the accident, but you're lawfully on the property. They don't even have to admit fault, but they may have a certain dollar amount, $5,000, $10,000 that they will give towards your medical expenses, having nothing to do with pain and suffering, but straight up medical expenses. So if you don't have insurance in place or you have copays or deductibles, even if you have insurance, that they would pay for that. And you don't have to prove fault for that. Now, not all businesses have that, but a lot of them do. So you have to inquire about that after the accident to see if they in fact have this no fault medical payment coverage.
Well, this has been absolutely fascinating. And of course, we really appreciate your time. Enrico Maio with Pellegrini, Seeley, Ryan, and Blakesley. Thanks so much for your time today.
Thanks for giving me the opportunity to speak with you. And like I said, if anyone has any questions or concerns, following a fall like this, either themselves or family member, they should give us a call. It's important, to make sure that you don't miss any of those deadlines we talked about, and document.
And if you want to get a hold of Enrico, you can do so 800-785-5399. Thanks very much.